Welcome to Prime. This Plumbing, Risk and Incident Management Education Program was designed to assist IOPSA member plumbers to achieve a high standard of occupational health and safety within their company. All the content of this Prime course was specifically chosen by OHSS Consulting to create a comprehensive occupational health and safety course that focuses on the specific needs of plumbers within South Africa. The material and content are based off of legislation, industry best practice, and standards that are used to achieve health and safety compliance. The materials and content used are designed to assist IOPSA member plumbers design, implement, and continually improve their occupational health and safety compliance in their businesses, on projects, on sites, and at their clients. It is the desire of both OHSS Consulting and the Institute of Plumbing South Africa that every member plumber undertake this course. The Occupational Health and Safety Act, number 181 of 1993, has the following objective: to provide for the health and safety of persons at work and for the health and safety of persons in connection with the use of plant and machinery, the protection of persons other than persons at work against hazards to health and safety arising out of or in connection with the activity of persons at work, to establish an advisory council for occupational health and safety, and to provide for matters connected therewith. Section 1. Definitions. Please refer to all definitions in your learner guide. There are additional definitions as per the regulations. Within the OHSS Act and regulations, a specific definition will be given so that the interpretation is fully understood in terms of occupational health and safety. At times, there are no definitions available within the Act or regulations, and then, in this case, the dictionary definition will be used. The reason for the Act to give specific definition to certain words is to ensure that employers and employees know and understand the application of legislation to their respective responsibilities and duties. Section 2. Establishment of Advisory Council for Occupational Health and Safety. There is hereby established an Advisory Council for Occupational Health and Safety. This means that South Africa has established an Advisory Council for Occupational Health and Safety. This Advisory Council for Occupational Health and Safety is a tripartite committee established in terms of the aforementioned Act. The purpose of this council is to advise the Minister of Labour on aspects of health and safety, insofar as it is covered by the legislation. Section 3. Functions of Council. The Council shall advise the Minister with regards to matters of policy arising out of or in connection with the application of the provisions of this Act, any matter relating to occupational health and safety, perform the functions assigned to it by this Act or refer to it by the Minister. The Council may, with a view to the performance of its functions, do such research and conduct such investigations as it may deem necessary, make rules relating to the calling of meetings of the Council, the determining of a quorum for and the procedure at such meetings, and generally relating to all matters which may be necessary for the effective performance of the functions of the Council, or subject to Section 6 of a technical committee. The Council may advise the Department concerning the formulation and publication of standards, specifications, or other forms of guidance for the purpose of assisting employers, employees, and users to maintain appropriate standards of occupational health and safety, the promotion of education and training in occupational health and safety, and the collection and dissemination of information on occupational health and safety. The Council may, for the purposes of the performance of any of its functions, with the approval of the Minister, and with the concurrence of the Minister of State Expenditure, enter into an agreement for the performance of a particular act or particular work, or for the rendering of a particular service, on such conditions and at such remuneration as may be agreed upon with anybody who, in the opinion of the Council, is fit to perform such act or work or to render such service. Subject to the laws governing the public service, the Minister shall provide the Council with such personnel as he may deem necessary for the effective performance of the functions of the Council, and such persons shall perform their functions subject to the control and directions of the Chief Inspector. Just as the employers and employees have certain duties to ensure they adhere to the law and work toward continual compliance, the Council for Occupational Health and Safety also have duties to ensure they uphold the goal of the OHSS Act, to provide for the health and safety of persons at work and for the health and safety of persons in connection with the use of plant and machinery, the protection of persons other than persons at work against hazards to health and safety arising out of or in connection with the activity of persons at work, to establish an advisory council for occupational health and safety, and to provide for matters connected therewith. The Council must advise the Minister on matters of health and safety policy arising out of or in connection with the Act, any matter relating to occupational health and safety, as well as perform the functions assigned to it by this Act or refer to it by the Minister. The Council may do what is needed in order to fulfill its duties as set out in the Act or prescribed by the Minister. This means that they can do anything to protect our health and safety, as long as they have the approval of the Minister. The Council can also give us standards, specifications, or any other form of information relating to occupational health and safety that will assist employers and employers, as well as users, to maintain appropriate standards of occupational health and safety. They can also do promotion of education and training in occupational health and safety, as well as collect or send out information on occupational health and safety matters. The Council may also use other companies to be able to assist them with their duties. Again, everything must be done with the approval of the Minister and be in line with the requirements of this Act. Section 4. Constitution of Council. The Council shall consist of 20 members, namely, the Chief Inspector, ex officio, who shall be the chairman, one officer serving in the department, the Workmen's Compensation Commissioner or his nominee, one person nominated by the Minister for National Health and Welfare, one person nominated by the Minister of Mineral and Energy Affairs, 6 persons to represent the interests of employers from a list of the names of persons nominated by the employers' organizations or federations of employers' organizations, 6 persons to represent the interests of employees from a list of the names of persons nominated by trade unions or federations of trade unions, 1 person who, in the opinion of the Minister, has knowledge of occupational safety matters, 1 person who, in the opinion of the Minister, has knowledge of occupational medicine and who was recommended by the Minister for National Health and Welfare, 1 person who, in the opinion of the Minister, has knowledge of occupational hygiene. The members referred to in subsection 1b, up to and including J, shall be appointed by the Minister. This means that the Council for Occupational Health and Safety will consist of the persons mentioned within this section. You will notice that there are persons who represent all areas of health and safety, who bring with them their own set of expertise. This allows the Council to have a well-rounded and balanced mindset when it comes to setting out standards of health and safety for us. Section 5. Period of office and remuneration of members of Council. The members of the Council referred to in Section 4.2 shall be appointed for a period of 3 years, and on such conditions as the Minister may determine with the concurrence of the Minister of State Expenditure. Any person whose period of office as a member of the Council has expired shall be eligible for reappointment. A member referred to in Section 4.1f, G, H, I, or J, who is not an officer, may be paid from money appropriated for such purpose by Parliament, such allowances as the Minister may determine with the concurrence of the Minister of State Expenditure. This means that the legal appointment of those stated in Section 4 will only be valid for 3 years, and thereafter new members can be appointed if the Minister so wishes. If the same persons are appointed, a new legal appointment must be signed. All members who serve on this Council who are not an officer may be paid out of a fund that the Minister has established for this purpose. Section 6. Establishment of Technical Committees of Council. The Council may, with the approval of the Minister, establish one or more technical committees to advise the Council on any matter regarding the performance by the Council of its functions. A member of a technical committee shall be appointed by the Council by reason of his knowledge of the matter for which the committee is established, and such a member need not be a member of the Council. A meeting of a technical committee shall be held at such time and place as may be determined by the Chairman of the Council, and in accordance with the rules approved by the Council. A member of a technical committee who is not an officer may be paid from the money appropriated for such purpose by Parliament, such allowances as the Minister may be determined with the concurrence of the Minister of State Expenditure. This means that technical committees can be established to assist and advise the Council with the approval of the Minister. A technical committee is appointed based on their knowledge of the matter for which the committee is established. We could refer to these ones as subject matter experts, someone or those persons who have competence in a certain field. A member of a technical committee does not need to be a member of the Council. All members who serve on this committee, who are not officers, may be paid out of a fund that the Minister has established for this purpose. Section 7. Health and Safety Policy. Let us start at Section 7 of the OHSS Act. This deals with a health and safety policy. The Chief Inspector may direct any employer in writing and any category of employers by notice of the Gazette to prepare a written policy concerning the protection of the health and safety of his employees at work, including a description of his organization and the arrangements for carrying out and renewing that policy. Any direction under subsection 1 shall be accompanied by guidelines concerning the contents of the policy concerned. An employer shall prominently display a copy of the policy referred to in subsection 1, signed by the Chief Executive Officer in the workplace where his employees normally report for service. In short, it means that each company in South Africa has a responsibility toward the occupational health and safety of its employees and any person who may be affected by their works. Thus, government requires companies to develop their own commitment to OHS by designing and sticking to a policy of OHS. This health and safety policy must be documented, include a description of their organization, include the arrangements for carrying out the policy, include the arrangements for reviewing the policy, include guidelines concerning the contents of the policy. This could be methodologies on how the company will carry out the contents of the policy. It must also be prominently displayed where the company's employees report for work. In other words, it should be visible to employees at a point where all employees can see this policy. Section 8. General duties of employers to their employees. Let's now have a look at Section 8 of the OHSS Act, the duty of the employer toward their employees. Section 8.1 starts off by saying that every employer shall or must provide and maintain, as far as is reasonably practicable, a working environment that is safe and without risk to the health of his employees. Let us stop and look up the meaning of reasonably practicable. This means having practicable regard to the severity and scope of the hazard or risk concerned, the state of knowledge reasonably available concerning that hazard or risk, or any means of removing or mitigating that hazard or risk, the availability and suitability of means to remove or mitigate that hazard and risk, and the cost of removing or mitigating that hazard or risk in relation to the benefits deriving therefrom. Now moving on to Section 8.2, it says that without derogating from the generality of the employer's duties under subsection 1, meaning that the overall responsibility that they have toward health and safety, we cannot take away from that. But the matters to which those duties refer include in particular. In other words, it is now telling the employer specifically what must be done in terms of health and safety. And this is also a very good key or a very good guide in order to develop a good health and safety policy. Let's start by looking at 8.2a, the provision and maintenance of systems of work, plant and machinery that, as far as is reasonably practicable, are safe and without risks to health. So yes, it's not just the provision of a system of work or a safe system of work, but also the maintenance of such a system. This maintenance of the system means a continuous, ongoing methodology to ensure that the systems that have been put in place, or the processes to keep people safe, are continually looked at, continually monitored, continually reviewed to ensure that employees are safe. Always looking at it from a reasonable and practical aspect. The next aspect is looking at taking steps, again, as may be reasonable and practical, to eliminate or mitigate any hazard or potential hazard to the safety or health of employees before resorting to personal protective equipment. This HIRA program, or hazard analysis and risk assessment, or hazard identification and risk assessment, helps us to analyze what health and safety hazards or dangers there are that could impact employees. We then look at reasonable and practical measures to first of all eliminate these completely. If this is not possible, we move over to a mitigation. Mitigation means to make safer. And so we use a hierarchy of control. A hierarchy of control helps us to start with the safest way of doing something and slowly move to a less safe. So as you noticed in section 2b, it says that you eliminate or mitigate before resorting to personal protective equipment. In other words, PPE is the last resort. Before resorting to PPE, we want to try and make the work our employees do as safe as possible. Point C says making arrangements for ensuring, again as far as reasonably practicable, the safety and absence of risks to health in connection with the production, processing, use, handling, storage, or transport of articles or substances. And so whether you are manufacturing such articles or substances, or whether you are using them, handling them, or storing them, or transporting them from one place to the next, these substances will pose a risk to your employees. And so we want to ensure that there is complete safety and absence of risk to health to our employees when using any articles or substances. This could be in the case of lacquer thinners. If you had to buy thinners for your employees to use while working on site, then how are they supposed to use it? You see, the start of this point says making arrangements for ensuring the safety and absence of risks. These arrangements are not just passive, but also active processes to help employees understand how to use them, how to handle them, where and how to store them, how to transport these. So when it comes down to the health and safety of our staff, our employees, or anyone else that may be affected by the risks and hazards that are exposed to ourselves on site and the scope of work we perform, we want to make arrangements for ensuring the safety of these risks to health. Then section 8.2d starts with establishing, so we need to now find out, again, as far as is reasonable, what hazards to the health or safety of persons are attached to any work which is performed, any article, any substance which is produced, processed, used, handled, stored, or transport, and any plant or machinery which is used in your business. And you shall or must, again, as far as reasonably practical, further establish what precautionary measures should be taken with respect to such work. Again, not just the work, but any articles, substances, plants, machinery, in order to protect the health and safety of persons. Now notice it says safety of persons and not just employees, and that is because we are not just looking after the health and safety of the employees performing that work. We are looking at the health and safety of any person who may be exposed to the dangers that that work will provide. And then it says that the CEO or the employer shall or must provide the necessary means to apply such precautionary measures. Again here, we are being told to look at what hazards to the health and safety of persons are attached to any work which is performed. This is an overall holistic approach to risk management. We need to find out what risks and hazards our entire scope of work of the company is going to not just affect our employees, but affect any person. And this will include the use of tools, the use of machinery, any use, handling, or stored, processed, or transported article or substance, as we mentioned in point C. Then any use of plant or machinery inside the business or outside the business in order to perform our scope of work. In other words, whatever you are doing, whether it is an actual process or a new process, whatever you need to do in order to keep your company running is a part of this work which is performed. It could even start with a very reception area where we have a person welcoming our clients, our customers, or any visitor off the road. Have we seen, have we checked, have we established what safety hazards there are to these persons? Have we then taken a look at the individual visiting us as well? Look at the visitor, the client, the customer that comes through to you. Is there any exposure to danger when they arrive on site? All of this needs to be written down. Then we need to find a good way to prevent them from being injured on site, getting ill health on site, or any of the risks and hazards that we are exposed to in our company affecting any other person. Now we move over to 8.2e. This says that an employer must provide such information, instructions, training, and supervision as may be necessary to ensure, again, as far as reasonably practicable, the health and safety of persons at his work. When we provide information, instruction, training, and supervision, this is all in the interest of keeping a person safe. So from the information side of it, it is all information. As you notice, it's the information that may be necessary to ensure the health and safety of persons. This would include information on risks and hazards. Then, the information on the precautionary measures to prevent these risks and hazards from hurting the person. The instruction part of it is a direct methodology. Instructions help us to specifically tell the person what they need to do. So we take information and we add understanding. So we don't just have knowledge of what is happening in the company. We don't just have the knowledge of the risks and the hazards, and we don't just have the knowledge of what to do to keep it safe. But we add that instruction, that specific methodology of how to take that precautionary measure and use it to keep yourself safe. Then we move on to training. This could be in-house training, such as the safety awareness program, the safety induction program for our company, even an employee orientation to help employees get a fay with what is happening in the company, such as training them on the risk assessment, on the articles, substance, plants, machinery, as we heard earlier, and how to protect themselves from these necessary dangers. And supervision as may be necessary. So here could be one of the appointments that an employer can make in terms of a supervisor. We would call this person an 8-2E. And why is that? Well, they are being appointed because the duty of the employer is to appoint them as a Section 8, duty of the employees, subsection 2.E, providing supervision. Yes, so this would then become a point of appointment. You would now have a person appointed as a supervisor under Section 8.2E. And this is also how most appointments are done. Reading through legislation, we then identify where it tells us where responsibilities of certain parties are put in place and how we can hand them over or appoint responsible people into those positions, all in order to fulfill legislation. And by fulfilling legislation, we are fulfilling our compliance to legislation. Let's move on to point number F. As far as is reasonably practicable, not permitting any employee to do any work or to produce, process, use, handle, store, or transport any article or substance, or to operate any plant or machinery, unless the precautionary measures contemplated in paragraph B and D or any other precautionary measures which may be prescribed have been taken. This does not mean a policing of employees. However, the supervisor that has been appointed should be a competent person, and we'll get to this a little bit later on in this training course. What is a competent supervisor? You see, surely someone who is supervising you should not only know the risks and hazards that you're exposed to, but also how to safely apply precautionary measures in order to protect these employees that they are supervising. So any supervisor should know that if you are working, producing, processing, using, handling, storing, or transporting articles or substances, or if you are operating plant or machinery, that the precautionary measures are known to you and that you are actually working in accordance with these precautionary measures. Let's take the example of working with a forklift. This would be operating a piece of plant. If you had to operate this piece of plant, such as a forklift, then you would no doubt understand, being trained as a forklift operator, that there are certain dangers. Your supervisor should also know the dangers. Perhaps they don't know how to actually operate the forklift, but they will definitely know the dangers of the forklift. Now, why is that? How can a person know the dangers of operating a forklift, but then not be trained in the operation of a forklift? Well, this is where a risk assessment, safe work procedure, method statement, all of these documentation outline how to operate the forklift, what the dangers are in operating the forklift, and then apply to your specific area. Now, what do we mean by that? Well, when you get into a forklift and just operate it in a wide open space, so if you can imagine you're in a warehouse, there is nothing around you, just one big open space warehouse. You're in the center of it, and the walls or any obstacles are kilometers away from you. And so you are in this forklift and you are now operating it. There are specific risks and hazards to operating that forklift, even though there's nothing around you. You see, the forklift itself is a danger. The forklift operation becomes the very exposure to danger or a hazard. And these come with their own risks. Now, supervising you, we would need to know these risks. But not everyone uses a forklift for the exact same thing. Yes, it is used to lift objects, but everyone lifts different objects. And so the supervisor, as well as the operator, must know and understand the various dangers of the applied scope of work. Where are we using that forklift? What are we using it for? What are we lifting? Where are we moving it? All of those specific scopes of work now become what we term site specific. Then the environment that the forklift is in. What is it traveling on? What is it traveling up? Where is it going into? Thinking of your own work area where a forklift might be used, you will then notice quite a few risks and hazards that are in the surrounding environment. All of this must be taken into consideration when working out a risk assessment, when performing an understanding or instruction or giving information on the use of such a forklift in a specific environment. Now, section F also goes further and says any other precautionary measures which may be prescribed. These may be directly from the manufacturer. You see, the OHSS Act doesn't specifically tell us how to operate plant or machinery. And so it states that we need to reasonably and practically, what does that mean again? We need to identify the severity and scope of hazards concerned. We need to also understand what knowledge is available concerning this hazard. What is the availability and suitability of the means to remove that hazard? And then what is the cost of removing it against the benefits that we derive from it? That reasonably practicable attitude is what an employer must have. So it means being active. We do not wait to get that information. Rather, we go and research it. We actually physically take an active part in looking for the safe means, these precautionary measures that must be taken. Then we look at section 8.2G, taking all necessary measures to ensure that the requirements of this act are complied with by every person in his employment or on premises under his control where plant or machinery is used. Now notice we are covering any person who may be affected by the dangers of the use of plant or machinery. And so if machinery is being used, any tools are being used on site, and you have somebody that is visiting you on site, they fall under your control. And that is because you're inviting them onto your premises. And as an employer, you are ultimately responsible for anything that happens on that site. So because the risks and hazards that you have outlined and the precautionary measures that are attached to them have been instructed and trained, and you have a supervisor over your employees, you now also need to ensure that any person over and above someone in your employment is also protected from those dangers. So many companies have a specific rule that you cannot work or walk alone around the environment if you are a visitor without somebody being with you from the company. And so you need to ensure that your host or the person that invited you to the company, the person that you are seeing in the company, walks with you while you are in that specific area. All of these are the necessary measures to ensure that the act is complied with by every person. So supervision is key to ensuring that each person is being compliant to the OHSS Act. This means that you need to know what the OHSS Act says. You need to understand how to apply the requirements of the OHSS Act before you are able to then take necessary measures to ensure that others are doing that. Now notice point H. Enforcing such measures as may be necessary in the interest of health and safety. And so there might come a time where someone is not doing what they are supposed to be doing in terms of health and safety, either by not doing something correctly or by doing something that is not correct. And these acts or omissions by employees or mandatories or any visitor that comes to your site may be a cause that will create a risk or hazard to your company. It may endanger the life of the people around them when they do something or do not do something in the interest of health and safety. And so it is the responsibility of an employer to enforce measures. This means at times that you might have to issue a non-conformance. If somebody does something wrong, you may have to put in a disciplinary procedure in order to show the severity, the weightiness of the actual act, as well as what it is standing for in the interest of health and safety. Now notice section 8.2i. Ensuring that work is performed and that plant or machinery is used under the general supervision of a person trained to understand the hazards associated with it and who have the authority to serve and ensure that precautionary measures are taken by the employer. Now, this person, again, we find another appointment within this piece of legislation. We call this person an 82I, someone who is more technically minded, because they now have information that is plant or machinery related. And this person, who is a general supervisor, must be trained to understand the hazards associated with that plant or machinery being used. But notice it also says that they need to have the authority to ensure that precautionary measures are taken by the employer. Now, what is this authority that we are talking about? We are not just saying somebody that has been elected in a high position in the company. When we speak of authority, or when somebody comes across as authoritative, it means that they have the knowledge, understanding. In other words, this person is competent. They know and understand, and so when they speak, they are speaking from a position of authority. And so when we appoint someone into this position in our companies, we want to ensure that this person speaks and uses the knowledge, training, and all the information that they have been given about the risks and hazards specific to the task being performed under the employees who are working, so that when they issue instructions, when they give information, when they train any person under their supervision, they are coming from a place of authority. Now, moving on to section J, which is the last point, section 8.2J, causing all employees to be informed regarding their scope of authority. So what is their scope of, what are they allowed to do, what are they not allowed to do, what is their specific job, and what must they do to ensure they comply with this act. Now, regarding the scope of their authority as contemplated in section 37 rather, 1B, this is basically stating the acts or omissions, as we mentioned earlier, what they can do and what they are not allowed to do in a company. Now notice again, earlier in section 8.2, we are being told to look at risks, we are being told to look at hazards, and then set out those precautionary measures and ensure that everybody is in compliance with the act, and then taking the necessary precautionary measures, making sure enforcing such measures that may be necessary. All of this comes down again to a reminder, making sure employees know and understand exactly what they need to be doing in relation to health and safety. And this scope of authority is how they are allowed to act and what areas are they not allowed to perform any work that might be dangerous. So let's look at one example. If an employee is appointed as a first aider, you see, you cannot perform any first aid unless you are trained in proper first aid. So as somebody who is trained in first aid, level 1, level 2, level 3, they'll be able to know how to give CPR to a person who is not breathing, whose heart is not beating. And this CPR that needs to be performed can only be done by a trained and qualified person. Their scope of their authority means that if they have a valid certificate, they are allowed to perform CPR in terms of their training. If they are not trained, are they allowed to perform CPR? Absolutely not. If an employee has a company vehicle but does not have a valid South African license, are they allowed to operate that vehicle? No. That would be an unsafe act that could lead to an incident or an accident. And so we need to ensure that employees are informed regarding the scope of their authority. And why is that? Because they represent you as the employer. And as the employer, you need to ensure that any person under your control are not exposed to the risks and hazards, the dangers of your working environment. In summary, employers are required to provide and maintain a safe working environment, provide and maintain safe plant and systems of work, which would include identifying, assessing, and controlling risks and hazards, providing information, instruction, training, and supervision of employees to ensure health and safety, then ensuring the safe use, storage, and handling of substances or articles, providing adequate facilities for staff in order for their safety and health, as well as the health and safety areas that need to be looked after. And then consult with employees and also consult with health and safety representatives about occupational health and safety. Section 9. General duties of employers and self-employed persons to persons other than their employees. Every employer shall conduct his undertaking in such a manner as to ensure, as far as is reasonably practicable, that persons other than those in his employment who may be directly affected by his activities are not thereby exposed to hazards to their health or safety. Every self-employed person shall conduct his undertaking in such a manner as to ensure, as far as is reasonably practicable, that he and other persons who may be directly affected by his activities are not thereby exposed to hazards to their health or safety. Every employer must know and understand the type of work they perform, the machines, equipment, tools, materials, and method of work performed, and then identify how this can be dangerous to others who are not part of the company. The employer should know what can harm them, how it can harm them, and why it harms any person. An employer must ensure that when their employee performs work, that work doesn't harm others. People who do not work for your company do not know your risk assessment, your safe work procedures, your safe operating procedures, and have not been inducted into your safety system of works, and so they do not know what can harm them. The employer or self-employed person must protect these persons and ensure that they are not harmed. How can they do this? The picture on the left can help any person, regardless of whether they work for the company or not, to understand that the surface where the work is being performed is hot, and this will lead the person to know that they could get burned or harmed by it. This form of protection is low but effective. We would no doubt want to use a more effective and higher form of protection than a simple sign. Can you think of something? Section 10. General duties of manufacturers and others regarding articles and substances for use at work. Any person who designs, manufactures, imports, sells, or supplies any article for use at work shall ensure, as far as is reasonably practicable, that the article is safe and without risk to health when properly used, and that it complies with all prescribed requirements. Any person who erects or installs any article for use at work or in any premises shall ensure, as far as it is reasonably practicable, that nothing about the manner in which it is erected or installed makes it unsafe or creates a risk to health when properly used. Any person who manufactures, imports, sells, or supplies any substance for use at work shall ensure, as far as is reasonably practicable, that the substance is safe and without risks to health when properly used, and take such steps as may be necessary to ensure that information is available with regards to the use of the substance at work, the risks to health and safety associated with such substance, the conditions necessary to ensure that the substance will be safe and without risks to health when properly used, and the procedures to follow in the case of an accident involving such substance. Where a person designs, manufactures, imports, sells, or supplies an article or substance for or to another person, and that other person undertakes in writing to take specified steps sufficient to ensure, as far as is reasonably practicable, that the article or substance will comply with all prescribed requirements and will be safe and without risks to health when properly used, the undertaking shall have the effect of relieving the first mentioned person from the duty imposed upon him by this section, to such an extent as may be reasonable, having regard to the terms of the undertaking. Every employer must know and understand the dangers of the products they supply to persons, and then inform the person of the dangers. Sometimes it is fairly simple. Like a nice hot cup of coffee, you may simply have "Contents hot" written on the cup, and the person who buys the coffee can read that the coffee is hot. If they burn themselves, the employer of the company that sells the coffee is not held responsible. But what if a company is selling something a lot more dangerous, like thinners? Thinners is a hazardous chemical substance and is governed by a separate piece of legislation, not just the OHSS Act. The OHSS Act here in Section 10 is reminding employers to make sure their product complies with all prescribed requirements, or in this case we could say regulations, SAN standards, SABS standards, or any other standard. When you buy a bottle of thinners, you will receive a contents label with information that is important for the correct use of the product being supplied. You will also have access to an MSDS, or Material Safety Data Sheet, which includes all the dangers and first aid measures of the substance. This is how Section 10 employers protect any person who buys their products, services, machines, or plant.